discussion off? Thank you. On behalf of the EPC, I'd like to welcome you all to this policy dialogue on using frozen Russian assets to support Ukraine. We hold this event in cooperation with the US mission to the EU. It's part of our long-standing Transatlantic Challenges project. The subject today is highly topical and highly important. As US Secretary of State Antony Blinken recently said, Vladimir Putin must pay to rebuild what he has destroyed in Ukraine. And this is absolutely correct. Indeed, there is broad agreement that Russia needs to pay reparations to Ukraine for its large-scale destruction of the country, while EU member states broadly agree to use the windfall profits. There still remains some legal concerns surrounding this issue. And this is not just from the EU, but from other countries as well. The upcoming G7 summit is going to be the next sort of point on the roadmap to getting our hands on this money. They'll be meeting in Italy very shortly, and there's going to be a proposal on the table that's going to be discussed vis-a-vis a loan secured by frozen Russian assets. This is going to be discussed in Italy. Hopefully, there's going to be a positive outcome. Ukraine really needs this money, not only to rebuild and reconstruct the country, but also for immediate needs, including weapons deliveries, etc. So this is what we're going to be talking about today. And we have really a great group of speakers who are experts in this field to give us their insights, you know, what we can expect, what the challenges remain, etc., etc. And I also want to draw attention to a forthcoming EPC paper, actually by one of our speakers, Yuliya Ziskina. I hope I pronounced that correctly. She's online. This paper is exactly on this topic. It's answering many of the questions that are out there, and it will be published in the next couple of weeks. So please keep your eyes on that. I'm now going to hand over to our moderator today, my colleague, Svitlana Taran, who's a senior fellow at the EPC and the Kyiv School of Economics. So Svitlana, the floor is yours.
Thank you very much, Amanda, and good afternoon, everyone. You did my job with introductory remarks about the topic, so I can then quickly go to introduction of our distinguished speakers. And as you mentioned, yes, our discussion today is the second one in a row. The first discussion on the same topic was about 2 months ago, and that was a meeting organized with our partners Ukrainian Prism and with participation of the Minister of Justice of Ukraine, Denis Maluska, where he presented actually Ukraine's position on why Russian immobilized Russian sovereign assets should be confiscated and transferred to Ukraine, and that Ukraine doesn't actually have a lot of time for any further delays with this decision. And today we would like to have more expert discussion with our experts also from Ukraine, from UK, US, and EU, of course, to elaborate and facilitate this discussion on the eve of G7 forum, G7 summit next week. And we want to discuss what are the possible options are being considered now, what is on the table of G7 members, and also what are the major implications for international law and for national legal systems in case of positive decisions about these options, and what major concerns still exist among EU members, because some members are really reluctant reluctant to go further with this very more ambitious decisions, and what are possible recommendations or reforms should be introduced just to make these countries change their position and to actually to move ahead with this very urgent decision. Let me introduce first our speakers, distinguished speakers. We have 3 speakers in our room and 3 speakers online. First, we have today with us Dr. Thomas Grant. He's a senior fellow at the University of Cambridge, namely in, sorry for names because it's for me, Lauterpacht. Center for International Law at the University of Cambridge, and also he's a visiting fellow at the National Security Institute at George Mason University in Arlington, Virginia. Thomas is one of the leading world's expert in public international law, with close to 30 years experience in this area, and he also authored a number of publications on Ukraine and on Russia's war against Ukraine, and suggested a multilateral action model on reparations, including developing an effective system for reparations and compensation for Ukraine and Ukrainians for damage caused by the Russian Federation. The next, our distinguished speaker is Peter Csonka. He's a deputy director of the Justice Policies Directorate of DG Just, European Commission. Peter has a solid, also has a solid experience in international and European policy making, and also a specialty in public international law. Next to me is Anna Vlasyuk, and she's from Ukraine. She came here from Ukraine, and she's a legal research fellow at Kyiv School of Economics and a member of International Working Group on Russian sanctions. Her work is focused on legal aspects of sanctions, as well as the issue of possible confiscation of Russian sovereign assets. And also we have 3 speakers online. First, I would like to introduce Martin Sandbu. Martin is an economist. He's an economics leader writer for the Financial Times. He has been a senior research fellow at the University of Pennsylvania and a postdoctoral research fellow at Columbia University. He is also an author of numerous publications on economic dimensions of Russia's war against Ukraine, and including frozen Russian assets. Also, we have with us Ivan Horodyskyy. Ivan is a non-resident senior fellow with the Strategic Litigation Project at the Atlantic Group. He's a co-founder the Dnistriansky Center for Politics and Law, where he manages projects related to compensation for Ukrainians for damages caused by Russian aggression. Ivan is also a president of the Ukrainian Bar Association. And also, we have, Amanda mentioned already, Yuliya Ziskina. She's an American expert and also with Ukrainian roots. She's a lawyer at Quinn, Emanuel, and legal counsel at Razom, which is a non-profit organization supporting humanitarian aid to Ukraine. Yuliya contributed to the preparation of the so-called Repo Act, the Rebuilding Economic Prosperity and Opportunity for Ukrainians Act, and also in the US, and to the change, she also advised, were advisor for changes to national legislation on the use of Russian assets in some other countries. She's publishing her paper at EPC, which is no more excuses, rebunking arguments against seizing Russian state assets for Ukraine. So let us start our discussion, and I'm going to pose questions for every speaker, but and please take about 6-8 minutes for your answers. But also, if other speakers has some comments to add, so you can also jump in and add your comments at any stage. And also then after our discussion, we will turn to our audience for Q&A. So Thomas, I would like to start with you. After 2 years of invasion of Ukraine by Russia, there are still a lot of discussions and disagreements about on different levels, on policymaking levels and on expert levels, about legal basis for using Russia assets, including direct confiscation of these assets and transfer them to Ukraine. And I think that this some disagreements or arguments actually prevent some countries from more decisive decisions in favor of Ukraine, in favor of transferring assets to Ukraine. And these countries are reluctant because they say that every move should be underpinned by law, and that there is no sufficient, unfortunately, according to them, sufficient legal basis for example, such measures as direct confiscation of Russian assets in favor of Ukraine. And but on the other hand, there are experts like you and some other prominent experts that support this idea, and that actually established the legacy for this idea for transferring Russian sovereign assets under the international law doctrine of state countermeasures. And I would like to ask you how Russian aggression is Russian violations of international law is determined by international law, and what is the scale of the violations of Russia, and also would you please explain how this doctrine of countermeasures would work as a legal ground for using and for transferring aggressors' assets? Thank you very much.
Thank you for that kind introduction. Thank you, Amanda, for that kind. Oh, sorry about that. So this is the front row will have heard the very respectful preamble about the rights of states. The back row won't have heard that part, which we're going to move beyond that part in any event. Sovereign immunity is a basic principle of the law. So states, we would be actually alarmed if our own governments in Europe, America, East Asia, we'd be rightly alarmed if governments thought that it was right to simply take the assets of any state, even Russia's assets, without giving this matter very careful thought, very careful consideration, because sovereign immunity really is that important to how international law works. It's not just any other rule, it's one of the basic rules. Of course, it's also a basic rule that boundary entitlements, territorial and spatial entitlements between states, once settled, stay settled, and it's only by consent of states that we change boundaries. If you go back 100 years ago, the people who did my job would have told you it was a different picture. They would have told you conquest is actually one of the roots of title. You can gain territory, you can gain spatial entitlement by invading your neighbors. That changed resolutely after 1945. As a sort of parenthesis, I would observe the Soviet Union, for its many, many faults, had the one virtue of being almost religiously attached to the idea of territorial stability. It was a doctrine of faith in Soviet international law thinking, but not so much in the thinking of the Russian Federation. This goes to Svetlana's question about the magnitude of the Russian violation. It really is a very serious attack, of course, on Ukraine. That's self-evident. I don't need to say that to Ukrainians. But it's also an attack on a settlement that has served us extremely well for almost a century, and that is the settlement of this issue about spatial entitlement and boundary regimes. And the striking thing about boundaries is that, in a very simple sense, they are legal arrangements between pairs of states, dyads. But the thing is, they also serve multilateral legal purposes. A boundary, like any property entitlement, even under domestic law, has a signaling purpose. It signals to me and to the rest of us, in the case of boundaries, it signals to governments which areas of the world are under the responsibility of which states. In other words, a set of multilateral expectations grows out of any given state-to-state boundary settlement. Now, the law of countermeasures is an area of high sensitivity in international law. It's an area of high sensitivity because it harks back to an era of law when self-help was the only way forward when you had disputes. 150 years ago, certainly, you almost never had, you had very, very few cases of agreed arbitration or adjudication. We've moved away from self-help. We've therefore moved away from countermeasures. We prefer to settle our difficulties through orderly process, through agreed procedure. But when international lawyers have considered the evolution of our law in modern times, we have had to concede that there is still a space in international relations in which states do retain a limited right of self-help. And this doctrine of self-help we call countermeasures, and we still recognize that under certain narrow circumstances, the state may invoke a countermeasure in order to avoid the legal responsibility that would otherwise arise from violating the law. Sometimes laypersons, when they hear about countermeasures, think it means that it lets you tear up the law. Most certainly not. Countermeasure temporarily avoids the consequences of a violation. It does not deny that the state invoking the countermeasure is about to embark on a violation. What it does, though, is it creates boundaries within which the violation takes place and within which, in future, the state must reverse its illegal act. It also sets as a fundamental term of the countermeasure that it must be calculated to induce compliance by an other state with that state's obligations. Now, what follows from that, and I'm running over my time, is that there has to be an antecedent breach of international law by a state in order for another state to invoke countermeasures. Now, obviously, Ukraine is the target of this extraordinary aggression since really 2014, escalating in 2022. So Ukraine is a state entitled to take countermeasures. I think one of the things that has given our governments pause is the question whether we, other states, Europe, America, Britain, East Asia, whether as states not directly subject to the aggression, we have a right of recourse to countermeasures. I would refer you to the work of the International Law Commission of the UN in 2001, when the Commission adopted Articles on State Responsibility. It was a half-a-century project involving the world's leading figures, not just of one generation, but going back really to 1948, thinking about this problem for decades. What they agreed to in 2001 was that a countermeasure is available to a state other than the state directly affected by the violation, where the violation has a particular effect on the rights of the state, but also in a separate circumstance. And that is where the violation is of such a character as to radically change the position of other states in respect of the obligation that was breached. That's a bit of a mouthful, but that's roughly how the ILC expressed it. And it's that latter heading, the concept of a violation that radically changes the position of all the other states to whom the obligation is owed. It's that concept that I think we should urge our governments to think carefully about in this circumstance. And that goes back to the point about boundaries and spatial and territorial entitlement. Because boundaries do, in fact, create an ordering mechanism that we all rely upon, because they create expectations that we all count upon, for Russia to overturn the presumption of settled boundaries is actually a direct damage to the other countries actually every country. I would just sum up by pointing out that before 2022, you could go to Mariupol and be very sure about whom the ultimate authority was in that place, and in regard to the people in that place, and in regard to the assets and liabilities in that place. And the answer was it was Ukraine. And before 2014, you could do the same. You could go to Sevastopol and also be absolutely certain that you don't need to go to Moscow for a final decision. You go to Kyiv. Well, now you don't know. In principle, you know, but in actual material practice, Russia has attempted to change that situation. I think there's a very strong case to be made that that does, in fact, trigger the heads of permissible countermeasures as the ILC articulated them in 2001 in Article 42. I'm going to leave it at that because I've run way over my 8 minutes, but thank you very much.
Thank you very much. And also one more question to you. So in order to address all these concerns and demand for more legal, stronger legal basis, do we need implement more practical steps or legal reforms to address these concerns and to make all our decisions very legally sound? Thank you.
Speaking, for one thing, one of the tremendous challenges is that every national jurisdiction in a well-regulated society has ample protections for individuals and corporations and other groups that have assets. We do not want our governments simply to take assets. We do not even want our governments to just take Russia's assets. We want our governments to think very hard about the legal basis for doing that and to be very clear about why the door is open to taking sovereign Russian assets, and also to be clear, for the benefit of all of us in the future, what the limitations on opening such a door are. And one of the important limitations is, first of all, the magnitude of the breach. We're not dealing with an ordinary breach of international law. I have argued elsewhere that, with the exception of Iraq's attempted destruction and seizure of Kuwait in 1990, it is a unique example in the post-1945 era. So that's one point. The other point is to be clear about the violation that is triggering the right to invoke countermeasures. We rightly are very concerned with reparation. We rightly point out Russia has refused to make reparation. But the reparative obligation is intrinsic to any breach of international law. Going back to the Khosov factory case in the permanent court in the 1920s, international lawyers have agreed and governments have agreed that when there is a breach, the duty to repair the breach inheres in the breach. So it would be risky to say that it is Russia's refusal to pay reparations that opens the door, because then you would suggest to parties in all sorts of relatively normal disputes that a mere failure or delay in the reparative obligation would open the door to this self-help remedy of countermeasures. And I don't think we want, for example, the government of an investor, where the investor is owed $10 million by a government in another country under a bilateral investment treaty, to declare that it could use countermeasures to pursue a sort of ordinary investment award. That would be opening the door terribly wide. That's why I think it's important to emphasize that the antecedent violation of the law that opens the door to consider countermeasures is Russia's invasion and forcible purported annexation of Ukrainian territory and the atrocities and associated breaches of really basic international law. And that at once opens the door, but also makes clear that there's a limit to how far we go. And I think making it clear to governments and to the Commission that we are not setting a precedent that throws open wide the doors, the windows, and the walls, such that countermeasures become the ordinary course. They should not. And that would be a terrible, it would be a mistake to overgeneralize the availability of countermeasures.
Thank you, Tom, for your intervention. I think that you will have more questions from the audience a bit later, but now I would like to move to Peter. And Peter, you are here as a policymaker, representative from the European Commission. And recently, EU countries approved a decision to use profits generated from Russian assets, from Russian sovereign assets, worth up to 3 billion euro. Estimated to finance military and humanitarian aid to Ukraine. This decision is like a first step, and it is very important because it's a first step related to Russian assets, but and it's could be called like an icebreaker. But this decision still is called by some countries is not very ambitious because it will not ensure adequate amount of funds needed by Ukraine to survive this war. And so my question to you is, what is the other, maybe more ambitious decisions or options are being considered by European Commission and by European countries, and can be potentially approved? And what are the concerns of EU countries, major concerns about these decisions, and including confiscation and transfer of Russian assets, and how European Commission is working on these concerns, and what is your plan to move further? Thank you.
much, Svitlana. Good afternoon to all of you. Thank you very much, Amanda, for the introduction. Good afternoon, colleagues. If I'm an expert in anything, it's more European law than international law. I have to manage expectations here, but I had the privilege or misfortune of sitting through 2 years of discussions in the Council.
Speak into the mic.
Okay.
Put it down a bit.
That is directly in my mouth then.
They can't hear at the back.
Okay. The added value of my presence here is the knowledge of having seen discussions for 2 years in the Council and elsewhere about the EU's windfall contribution model, which I have seen through from the beginning until the very end. So forgive me if I will avoid some of your questions, but rather focus on what we have done and perhaps flag some of the issues which are still under discussion. The first point I wanted to make is that so far, the only EU action which really has been brought to fruition is this windfall revenue model. And we are the only ones in the world that managed to put this into action. We have discussed this all the way with our partners, but so far it's only the EU that has acted and has acted decisively. Second point, the EU has and will stay by the sides of Ukraine until the very end, and we have committed very, very important resources of our member states and of the EU as such to help Ukraine. Today, the total amount that is committed is 98.5 billion euro, and it concerns military, humanitarian, and budget support, and it also concerns the hosting of Ukrainian citizens on EU territory. Now, like in many international conflicts, the EU has acted decisively upon Russia's aggression against Ukraine. Immediately in the aftermath of that aggression, the EU has adopted sanctions, and those sanctions are still being developed. So we have now 14 packages of sanctions adopted by the EU on the proposal of the Commission and of the High Representative. And the one package that was adopted immediately in the aftermath of the aggression was to freeze the assets of a certain number of persons and legal entities. So that's the freezing of private assets. So we make a distinction between frozen assets, which are private in our view, and the immobilization of sovereign assets, which belong indeed to the Russian Federation or its entities. Now, as a result of those sanction packages of the European Union, we have today 28 billion euro of frozen private assets and around 200 billion immobilized sovereign assets in the EU territory. Altogether with our G7 partners, there are around 280 billion US dollars of immobilized assets of the Russian Federation in the world. That includes, as I said, US, UK, Canada, and Japan as well. Now, the reason why we focused on windfall revenues is because they are extraordinary. And the word expresses the full meaning of what we mean by that. They would not have been accumulated in our financial institutions, those revenues, without EU sanctions. Without EU sanctions, those transactions behind which you have Russian entities would have been processed. And they would have gone through to destination, that is the investment firm or the central bank of such and such country, including our own member states, and Russia would have invested in bonds, securities, whatever. Except that with the sanctions, those transactions have been halted in February 2022, and as a result, the investments which have been already made, they started maturing and our financial entities, essentially central securities depositories, from now on CSDs, started accumulating cash, a lot of cash, which nobody expected they would have. Normally, cash doesn't stay on the cash balances of CSDs for longer than 24, 48 hours. Today, as I said, we have a very, very important amount of cash that has been accumulated. And what we have done was to make a distinction, legally speaking, between the assets, the principal, as we call it, and the revenues, the interest, which it has been generated and is being generated under the current favorable ECB interest rates on any such account. So the cash balances of the CSDs have started growing, and the idea was to tap into that part, because there, after some discussion, which took us more than a year, we came to the legal conclusion that those interests, those windfall revenues or extra revenues, do not belong to the Russian Federation. So our hypothesis from the beginning was that the interests do not share the legal standing of the principal, in particular because there is no contractual obligation between the CSDs and the Russian Federation about those revenues. And we looked at those contracts and we came to the conclusion that it is 100% sure, in our view at least, probably not shared by Russia, that those revenues are not not Russian property. So that's why we came with a model which we implemented in 2 steps, actually in 3 steps, but 2 legislative packages, 3 steps in the sense of 0, 1, and 2. You could argue that in the Commission people cannot count. In the 0 was to clarify an acting actual legal obligation on CSDs to manage as a bonus pater familias their cash balances, which they would do anyway. But the question was whether they could invest the cash returns in overnight swaps or short-term financial instruments, which they did in the interest of maintaining the value of the money and for their shareholders. Because the CSDs, like us, believe that this is not Russian money, but this is their money. And they still believe it is their money. So we made a first legal clarification in the first package of February this year that CSDs are indeed entitled to invest those cash balances in order to maintain the value of the assets. The second step, which we called step 1, was to ensure that our CSDs and financial entities which hold such assets keep those assets on a separate account, which we didn't call an escrow account, but that's what it means. And nobody can touch those accounts, and there has to be a separate reporting line concerning those assets. And the third and last and perhaps most difficult step was to ensure that those assets can be used for the sake of Ukraine. That happened a few weeks ago when in May, Council eventually agreed to step number 2, which essentially splits the revenues, windfall revenues earned into 2 parts and obliges the CSDs to make an extraordinary contribution, as extraordinary as the revenues, by transferring 99% of those revenues to the union budget, through which it will split into military aid and reconstruction aid. Today, it's 90% military aid, 10% reconstruction aid, but it can be revised, and there is indeed a legal obligation to review it every year. Now, there is a so-called buffer that we allowed financial entities of the union to maintain, and that is including the revenues that had been generated before February this year, and 10% of what they earn from now on. And if they don't use it for litigation purposes for the sake of maintaining the legal standing of those assets, then they have to pay this as well to the union budget. The union will transfer those assets, as I said, through two separate legal instruments to Ukraine, and the first tranche of payment should be done already in July. Now, you may wonder how this is compatible with the philosophy of sanctions of the union. Sanctions are meant to be temporary, non-punitive, and reversible. And that is the reason, the framework, why this package is meant to be a temporary package. It will go on as long as necessary, as long as our sanctions are maintained. But we all understand that indeed Russia has a legal obligation to pay for the damage it has caused and to repair that damage, not only for the Ukrainian state, but also Ukrainian companies and citizens. That's why we support the Register of Damage, which is now set up and started functioning earlier this year in The Hague. And we will change our status as a full participant in that register. And we will continue discussions on the Claims Commission, which should adjudicate claims for reparations in the future. Now, last word. We expect that the revenue that the windfall contribution model is supposed to generate will amount between 2.5 and 3.5 billion euro per year, again, depending on the current interest rates of the ECB. And in the ECB, we trust they will maintain, hopefully, this interest rate for a long time, for your sake and Ukraine's sake as well. And that means over the next few years, this will be quite a sizable amount of money that will be transferred to Ukraine beyond every other fund that is being set up or made available to Ukraine. I haven't mentioned the Ukraine facility, which is roughly 50 billion euro that we have set up over several years as well, which will also contribute to the funding. Now, last word on the G7 discussions, on which Svitlana, you asked me what we will do. This is a very good question. Discussions continue as we speak. This is a very high level, indeed, political discussion, not only a legal matter. And we are actively supporting those discussions. Whether there will be an agreement in Apulia in a few days on the US or any other idea of setting up a fund, which the Americans called first the Liberty Bonds Fund or the ERA Fund, in which the windfall revenues will be used as a front-loaded reimbursement, that is an open question. And I cannot say today whether the European Union will endorse that or not. What I can say is that the member states and the Union had indeed concerns of various sorts, including legal concerns about state immunity, about the impact on the markets in the European Union, and that determined our position so far in the discussions. But these are extraordinary times, and we will see what our leaders will decide. Thank you.
Thank you very much for your very detailed reply on my questions. Then maybe I will go then to Anna, just to try to keep all our speakers busy. So Anna, I would like, as was some options of possible using and Russian sovereign assets were already mentioned, but you are participating in many expert discussions, and there are some other options that are being discussed. And from your position as a legal expert, would you please shortly summarize all these possible options about Russian assets, and how do you, in your assessment about these options, and how they are sound, legally sound, how they can help Ukraine with increasing funds, and also how they can, for example, substitute of the ultimate goal of confiscating Russian assets. Thank you.
Thank you, Svitlana, for your question. Thank you, Amanda and APC team for organizing this discussion. So to your question, Svitlana, probably Peter would know more about these proposals. I can only comment them based on information available in public sources. So there is some media reporting about the proposed ideas to maximize the value of Russian assets. This is the term which is often used by policymakers when they put this proposal for the discussion, and there is yesterday's FT article about the loan which Peter mentioned, but it's difficult to analyze it based solely on the journalist reporting because there's not enough of financial and legal details to discuss. But we have two papers which give us more insight into this proposal. One is a paper authored by Dalip Singh and Lee Urquhart, Ukraine Reparation Loan, and this paper was co-authored by Dalip Singh when he was on a break from a governmental position in the United States. So probably it reflects some thinking in the US government around financial engineering and what can be done to maximize the value of Russian assets. Another paper which is helpful for this analysis is Gorodnichenko-Baker paper on using income from Russian assets or using the principal as a collateral for bond for Ukraine. So this is the paper written by two economists. Gorodnichenko is a professor of economics at Berkeley, and Becker is head of the Transatlantic Economics Institute at the Stockholm School of Economics. So to the idea of Ukraine reparation bond, first thing, it is really admirable that people with diverse expertise try to bring the instruments that are known to them to help Ukraine. So there are financial lawyers trying to bring their toolkit to help to resolve this issue. I think this is how this idea originated. The idea is that G7 countries issue collateral loan to Ukraine, which is a limited recourse loan, meaning that the only way of paying the loan will be the collateral. And the collateral is Ukrainian claim to reparation. And under this model, it is expected that in some future term, the international court or other institution will assess and confirm Ukraine's reparation claim towards Russia. And when the loan reaches maturity term, Ukraine will just set off what is due to the lenders by using Russian assets, and G7 countries will have legal standing to seize the assets to cover the loan. My concern with this proposal is that people who advocate for this proposal often say that it is more legally sound because it avoids issues of public international law and brings this whole discussion to the level of national legal systems, which I think might be a categorical mistake, because all the issues arising from Russia's aggression towards Ukraine, including the possible confiscation of Russian assets, originate and exist in the realm of public international law, and they have to be addressed at the realm of public international law. And there's also a lot of concern that other speakers have mentioned of limiting policy precedent. It is a genuine and legitimate concern of the countries who are to implement these measures. So the idea of building some financial engineering around the sovereign assets and then using this infrastructure to potentially seize the assets actually opens a bigger possibility of options, and it is more dangerous from the standpoint of international law or creating negative precedents for reserve currencies than going the countermeasures route. Countermeasures route is not an easy one, and as Dr. Grad mentioned, it has to be used with caution, but at least it is a very transparent procedure that everyone understands. It is international law known to all countries, while here we're in the realm of US financial law or other G7 countries' financial law, and their ability to foreclose on a loan when there is no other way to foreclose it other than using the collateral. So I believe this somehow more risky than it sounds. The idea proposed by Grodnichenko and Becker on using the proceeds from Russian assets to cover the coupon on the bond and then to use the interest, to use the principal to repay the bond is also very interesting, but also needs to be analyzed with caution, because I don't believe there is a problem with using the income on Russian reserves to cover the coupon. As mentioned by Peter, the EU has already established its legal position on it, that these proceeds do not belong to Russia. I would also be interested to know more about how these contractual terms that allow Euroclear to retain the income would work in a situation when the client is not withdrawing the cash, not by his choice, but definitely there must be something there that you have already considered. This is less problematic aspect, but the more problematic aspect is actually using the principal as a collateral, because to have something as a collateral, you need to have a legal title to it. So in essence, you cross the same Rubicon that you are afraid to cross when you are talking about the confiscation. And I also heard in some discussions about this proposal that it is a good idea because it incentivizes G7 states to keep assets immobilized, and it might incentivize them in the future to seize the assets. But also it is dangerous because it dilutes legal basis for all those actions. We know that assets are immobilized only because of the Russia's aggression against Ukraine, and there is a G7 statement that they shall remain immobilized until Russia pays full reparation, which is recognized by Ukraine. And if the countries move to seize their assets, again, it should be done on a very solid public international law ground, but not because these sovereign assets are tied up in some contractual arrangement or loan. And another more practical aspect of my considerations around this proposal is how it will affect the progress on the confiscation itself, because when you have an asset tied up in some as a collateral in a financial instrument, it essentially protects these assets from other claims to it, from confiscation or any other measures that can be applicable to the asset. So this is also not advisable because it moves, it's not a solution in a sense, it's kind of a procrastination. It moves the main decision to some future term, probably like 10, let's imagine a 10-year maturity bond. So it moves this decision in 10 years in the future. So it's again not the best approach from the legal standpoint.
Thank you very much. Very, very good. Thank you for your insights, Anna. And but we need to move further, and I'm turning to Martin now. And to economic arguments. So economic concerns are also very often mentioned, but by different EU countries and opponents of using Russian assets. And for example, a European Central Bank has been especially outspoken against seizing central bank money of Russia, and also and they are saying about possible economic damages of such decisions for especially EU countries. So, and according to Christine Lagarde, she stated that moving from freezing the assets to confiscating them, to disposing them is something that needs to be looked at very carefully. And it could entail breaking the international order that you want to protect, what you would want Russia to respect. So I would like to ask you, Martin, from the macroeconomic point of view, what are the major economic concerns and risks against using Russian revenues and also confiscating Russian sovereign assets? And shall we expect some severe shocks to the global economy or to the European economy, as it is suggested, and which concerns from this are valid and which are maybe a bit exaggerated, and how, and still, if there are concerns, how to mitigate possible risks? Thank you.
Thank you very much, Svitlana. Can I just check that you can hear me all right?
We can hear you.
Very good. You ask if we should expect any severe or negative economic repercussions of a seizure of the assets, and the answer is no. But you've given me 6 to 8 minutes. I will elaborate a bit. Before I elaborate, I'd just like to, in order to give a good answer, we need to make sure that we keep in our minds that the fact that we're talking about a lot of different policies here. I take your question, Svitlana, to be about the maximalist position of trying to take all the immobilized assets and somehow redirect them to Ukraine. Before I answer the question about what the economic consequences of that would be, let me just briefly address the fact that there's a range of proposals out here, which also, in principle, could have economic consequences, but we know a thing or two about them. So if I may briefly just follow up on Anna's remarks and what came before. The other options we have out there are, one, simply basically taxing the profits at Euroclear. That's what the EU has decided to do. Two, there is a possibility of shifting those profits into the present. That is the current US proposal, an act of financial engineering. But neither of those two touch Russia's money at all. Let's be very clear about that. That's the virtue of, for the EU, for the EU's point of view, the virtue of these proposals is that they don't touch Russian money. They touch Euroclear's profits, right? We had that explained by Peter, but I think we should put it in quite stark terms, because there is a risk here that we kind of divert attention from the topic that you're rightly asking us about. Anna mentioned 2 other very good ideas that are out there, which are not what is going to happen at Apulia, if anything, because one involves collateralizing the claims that Ukraine have on Russia. None in the leaderships of these countries are talking about this at the moment, of the G7 countries. The other involves collateralizing the assets themselves, but that's only possible if you claim that you can, in principle, seize them, take some sort of legal title to them, which the EU for now is ruling out. Okay. All of those options would probably be somewhat safer than, in terms of possible consequences, than just going for the maximalist position, even though they can give Ukraine more money than what is currently suggested. But I think it bears mentioning that the EU has now decided to take the Euroclear profits, and there are 0 economic consequences, certainly 0 negative economic consequences. It also bears mentioning that already in February, end of February 2022, the West blocked access to central bank reserves. That itself was an unprecedented act. That also has had 0 negative economic consequences for our financial systems. There's no sign of any other country pulling their reserves out of the euro or the dollar, for example. Okay, all of that is preliminary. What is the worry that the European Central Bank and others are warning about? In the case that we actually said, you know what, we are now going to seize these reserves and transfer to Ukraine as basically an advance on the reparations that we all agree that they are legally due in any case. We're talking about $300 billion. We already know that the estimated reconstruction cost is, maybe 500 billion, maybe $1 trillion, maybe more than that. So there's no doubt that Russia owes Ukraine much more than the amounts we're talking about. What could happen? Well, unfortunately, the European Central Bank has not been very explicit about this. It has not published its letter to the EU or to the Council. It speaks in very general terms, and this is where the discussion usually is at when policymakers and politicians raise this consideration. They talk about financial instability. They talk about loss of confidence in the euro. Very woolly, vague terms. So I just encourage everyone who's interested in this, whenever they're in a conversation about this, ask what specifically is meant. The two things that could be specifically meant, three things, but one of them I will not say very much about. So one could be that Russia will do something in return. Of course they can. They will do. They're already doing things in return for us supporting Ukraine. They are burning warehouses. They are, I mean, for 10 years they've been poisoning people on Western soil, right? They've already confiscated some Western assets in Russia. This will continue. I will just park that bit because it's kind of similar to the discussion. Well, can we give weapons to Ukraine? What if the Russians get angry? Okay. The kind of serious economic concern is, what about other big countries holding reserves in the West, dollars and euros predominantly? Countries like China, countries like Saudi Arabia and the other petrostates, big emerging market economies like Indonesia and Brazil. Now, we know from press reports and for some of us from private conversations that central bankers or finance ministers from these countries have explicitly said to European ones that we are a bit worried about what you're doing here. We may think about pulling our money out. There are speculations that this was done under Russian pressure, or at least at Russian request, to raise these concerns. So there's a bit of a game of blackmail going on. The two legitimate, I think, scenarios here are, one, that a lot of countries kind of as a punishment start to pull out, sell their euro or dollar reserves the day after Europe and the US and the rest of the G7 decide we are going to make a move on these reserves, the Russian reserves. So other countries will sell their reserves when we make a move on Russian reserves. Russia, of course, can't do anything because it's immobilized. The other theoretically legitimate concern is what happens over time. People will over time not want to place their savings in Europe or in the US. The first one, the kind of immediate financial crisis scenario, is totally unrealistic. In fact, when you try to work through the mechanics of how it would happen, it is virtually impossible. Of course, central bank reserve managers can sell Eurozone bonds and US treasuries. What would they then get? They would get euro cash and US dollar cash. I mean, that doesn't do anything for them, right? They're still exposed. That is money sitting in either private banks or central banks in the West. So they have to somehow they need to somehow move their money out of the West altogether. We're talking about $7 to $8 trillion, maybe a bit more. It is simply impossible to find alternative assets on any short to medium horizon for that sort of money. So a kind of escape en masse is simply not possible. Even if they could find those assets, who would they be buying those assets from? Well, they couldn't really be buying them from each other or from the private sector in their own countries, because then that part of the economy would still be exposed to the West. So the only way they could do this would be to find private investors in the West who have a lot of, I don't know, projects in China or in Saudi Arabia and are willing to sell them and instead hold the Western assets that these central banks would be selling. Well, basically what you're talking about is a reshuffling of ownership. Nothing disappears. Of course, in the short term, there would be disruption, relative prices would change. In the short term, the interest rates in Eurozone countries and the US could go up. But guess what? That interest rate is ultimately under the control of the central banks. The European Central Bank will be setting its interest rate tomorrow. The Fed sets the rate for the US. If suddenly the interest rates on Eurozone governments or the US government shot through the roof, the central banks are there to set that interest roughly where they think is right for the economy. So we have tools to address this. So the short-term financial crisis issue is just not very realistic. Let me be very brief on the longer term. Yes, it could well happen that if we no longer treat the central bank reserves of a country that has committed some of the worst violations of international law since 1945 as sacrosanct and deserving of protection by the international law that this country has broken, well, maybe they will think twice next time they have a surplus and they'll save it somewhere else. But you can only do that if you stop running surpluses with the Western world. China's economic model, of course, is based on export surpluses bilaterally with the Western world. Saudi Arabia's economic model is a surplus export model. So the only way to stop saving up claims on Western governments, ultimately, is by completely changing your economic model to one that doesn't rely on selling them more than you buy from them. So I just put this out there to make people realize that once you look through the mechanics of what this kind of loss of confidence in the euro or the dollar would mean, it means such a fundamental change in how these countries operate their economies that even that is not very realistic. And I'll just add at the end that economic policymakers in the West seem to be very worried that we're buying too much from China or that we are not exporting as much as we're importing. So if we went in that direction of more balanced trade, because these countries no longer want to build up savings claims on us, well, other parts of our policy programs seem to want precisely that. So what is it really we are worried about here? So last time I wrote about it, I said, we have nothing to fear but fear itself in this case. And I'm afraid that a lot of this discussion really is in part a kind of self-paralysis, a learned helplessness that avoids us from just taking the necessary steps. Thank you very much.
Thank you very much. Thank you. Very interesting contribution. Thank you. But I would like to also ask Yuliya question. Yuliya, you are here an American expert. So my question would be about U.S. position, how it has evolved, and what is the status quo now, and when do you expect this Repo Act will be effective? And how this process is connected to G7 negotiations. Thank you.
Thank you, Svitlana, for your question and for having me here. Before I go into the U.S. perspective, I would be remiss not to address my colleague Peter's comments, because I think this really goes hand in hand with what I'm going to talk about. So if you'll allow me a little bit, I would like to interject. First of all, I want to return to the question that was posed to Peter, which was avoided a little bit. But I think it's important to address your original question, Svitlana. The EU's agreement on only using the profits from Russia's frozen reserves, but not the reserves themselves, is, yes, a good first step. But it is, let's be honest, flat out inadequate to provide Ukraine what it needs to survive, and much less for reconstruction and reparations. The numbers just don't add up. It'll amount to approximately $3 billion per month, when the minimum to sustain Ukraine during the war is $50 billion a year. And the total compensation is already estimated at $486 billion. As Peter said, we recognize and we appreciate the contributions from the EU, because it's in the interest of protecting our collective global security and not just as a charity to Ukraine. But the flip side of this is that by providing Ukraine funding via the EU's own taxpayers, the end result is that the EU is protecting the assets of Russia, the genocidal aggressor, more than it's protecting its own taxpayers. And it's really the bare minimum measure. The main thing that it really does is it prevents Euroclear and Belgium from profiting off of the war. This approach also wrongly assumes that it's legally impossible to seize and transfer the entirety of the frozen assets, but that's simply untrue, as has been established by my colleague Thomas Grant and numerous other scholars. Our existing international legal doctrines and jurisprudence already reflect that point. On top of that, something that I think is not addressed very commonly is that the EU's agreement only concerns future profits accrued by Euroclear, and it does not apply retroactively to approximately the $5.2 billion in profits accumulated since the start of the war. These profits were accumulated as a direct result of immobilizing the assets in response to Russia's unlawful war. And Euroclear would not have had this about 11 times profit windfall if it weren't for Russia's illegal war. So retaining these past profits really positions Euroclear and Belgium as Western Europe's largest war profiteer. That is an uncomfortable truth, but that is very important for us to recognize. And to put it mildly, it's really troubling to see Euroclear's and the ECB's efforts to block the use of the 300 billion while also simultaneously retaining 2 years worth of windfall profits when the victims of war are in dire need of these funds to rebuild their lives. I think that should be talked about more, and I think that should be probably much more of a scandal than it really is. So, but to return to the US perspective, which aligns with this pretty well, and I'll start with the recent passage of the Repo Act in the US. So now the US has a law that puts beyond all doubt the president's authority to seize and transfer Russian assets, and it validates the full seizure of those assets as both possible and justifiable under international law, and specifically under countermeasures, as Dr. Grant explained. This is important not just for the law itself, but it's important because it changes the narratives of what we're talking about. It changes the narratives of these entire discussions of our legal and political conversations. It redraws these red lines that were set by Europe and that we've been consistently talking about through this panel. It legitimizes the use of countermeasures rather than pursuing these various creative strategies whose whole purpose is to avoid touching the assets. Seizing the assets themselves is actually possible, as Repo demonstrates, and it's also the best way legally and practically, as my colleague Anna Vlasyuk mentioned, to deliver the greatest amount of benefit to Ukraine in the fastest way. And it also makes it much harder to fall back on these legal excuses that we keep hearing. Repo also shows that international law is not set in stone. And I like to quote Martin on this from his article, and that international law is not somehow handed down on stone tablets from on high. It's formed by how states choose to act, and it continuously evolves. And Repo shows that it's possible to create a legal mechanism if one doesn't already exist. It erases these excuses of, oh, well, we just don't have the law for that. Well, then the answer is to make one, because that is the job of lawmakers and policymakers. However, that said, the current US proposal that Anna mentioned that's on the table to issue the bonds against the future profits generated by the assets, that's currently on the table. And this avoids directly confiscating the assets, which you might think contradicts Repo. But let me be very clear. The US is not pursuing this to avoid any legal prohibitions on seizing the funds. It has simply offered this as a possible compromise with the EU's reluctance and the red lines that have been politically and fairly arbitrarily drawn. So it should not be viewed as a substitute. For a variety of reasons, a lot of which Anna has done a very good job of explaining, but the very practical one is that it would provide a fraction of the full amount that could be available. We would be talking about 50 billion, which would be possibly enough to sustain a year's worth of war, but not 300 billion. But given the political reality, and again, let me be clear that this is not a legal question, but it's a political one. I want to be pragmatically ruthless in saying that it is a way to get funds to Ukraine now, which desperately needs them, but this is only an interim step towards actually making Russia pay.
Thank you very much. Thank you very much, Yuliya. If someone wants to maybe respond, react, would be nice. Mm-hmm.
Very briefly, both in relation to Yuliya's remarks and Martin's. Martin mentioned, or Martin used the expression maximalist approach and was referring to financial magnitude. if I understood him correctly, maximalist in the sense that it would take the most money from Russia and give the most to Ukraine, whereas the less maximal approach would, or minimal approach would take less money. But there, I think from an international lawyer's standpoint, it's not clear that that's really a maximalist approach. Doing the very unpleasant task, but you have to do this in all legal situations, of putting yourself in the other side's shoes. I suspect that an alert international lawyer in the foreign ministry of the Russian Federation would say that the collateralization approach, whilst very likely plausible if challenged in front of the courts of the European Union or its member states, and probably very plausible as a matter of European Union law or the law of EU member states, will not hold water, will not stand up against international law scrutiny, and, the Russian lawyer would add, your domestic law, and for this purpose, I'm sorry, I'll count the Commission's law as domestic. It's not public international, it's a separate legal order. That law does not change international law. Now, that's a fundamental principle. If international law says X, your domestic legislation cannot turn it into the opposite of X. That's just how it works. And I suspect that the attack that would be made against the collateralization approach would be to say that collateralization approach is an attempt to rewrite international law at domestic level, and you can't do that. It's just two different legal orders. The law of Nebraska cannot change the law of Massachusetts. I mean, it's that simple. Whereas the countermeasures approach admits openly that the seizure is a violation. We're not going to pretend we in the West are angels, but we are doing this within the framework that you, Russia, have left us. The framework of a recognized centuries-old system of self-help used in exigent circumstances with all those constraining factors and rules that have been tested time and again to discipline us, the ones taking the countermeasures. So it's I just be a little bit, put a little lawyer's scrutiny on the concept of maximalist approach. I take your point. You're talking about the amount of money, Martin, but I'm talking in terms of legal impact. I wonder whether actually the outright taking, the seizure under countermeasures, is actually less extreme, doing less than the, I mean, extremely rigorous domestic law, EU law thinking, but ultimately less risky.
Thank you. Thank you very much for your remark. And I would like also to ask one question to Ivan. He's with us. Martin actually mentioned about this, but I would like to reemphasize this question about possible Russian retaliation against EU companies and Western companies when there will be some decisions or transfers of Russian money. Russia said that already warned that the European Union would feel that Russia's countermeasures, as they call them, and it will feel it even if income from Russian assets will be transferred to Ukraine, not the principal assets, but also income from assets. And also, Martin also mentioned that Putin signed already a decree allowing the confiscation of assets inside Russia belonging to US companies or citizens in response to the EU move with REPO Act. So what would your estimation of the possible damage from these Russian countermeasures, as they call it, and to EU companies and to maybe EU economy? And what are your recommendations for companies and national governments, how to mitigate those risks? Thank you.
Thank you, Svitlana. I will answer this question, but first of all, I would like to pass a word to my esteemed colleague Yuliya, who asks for the concluding remark and announced that she needs to leave in a couple of minutes. So Yuliya, floor is yours, and then I will answer a question of Svitlana.
Thank you.
Thank you, Ivan. And I'm very, very sorry to interrupt, but I do have a hard stop at 4:30, so I want to make sure that we get to all of the questions. I believe, Svitlana, there was a question about future policy recommendations and what might happen at the G7 summit.
Yes. Yeah, this is a question actually for all speakers about future recommendations. What would be a course of actions after G7 summit? How we should proceed towards decisive steps? Thank you.
Thank you very much. This was covered a little bit, but my prediction is that I think there will be some kind of movement on the US proposal that we have previously talked about on the to issue bonds backed by profits on frozen assets. Again, as I said earlier, we do want to be pragmatic in recognizing that the situation in Ukraine is very bad and the prospect of supplementary funding from the US and the EU in the near term is quite thin. Ukraine needs this funding to survive. So this would be a step in the right direction. But I completely agree with Dr. Grant in that full seizure actually avoids a lot of legal and practical unnecessary complexities, and it's actually a lot more simple than this collateralization proposal. But if we must find a compromise, then we must find a compromise in the interest of getting Ukraine money. But it should not be viewed as a stopping point for a substitute for full confiscation. 50 billion can sustain for Ukraine for a year of war, but it cannot cover the full extent of the damage or reparations to victims. The bigger point I want to make too is that in the long term, this proposal really falls short of the rhetoric that often surrounds it to make Russia pay and to unlock the value of Russia's frozen assets. But let me be very clear, this does not actually make Russia pay, because it does not, strictly speaking, use the Russian assets themselves. If the idea is that the profits on the assets don't belong to Russia, then Russia is not paying. The loans are actually provided by investors, probably by governments. And this proposal is specifically designed to avoid confiscating the assets in order to abide by these political red lines that have been drawn by Europe. So again, while any measure to provide funds to Ukraine is a desirable one, this measure is not to be confused with accountability and responsibility for Russia. So unlocking the real value of the assets and really making Russia pay would be to confiscate the full 300 billion. Otherwise, this is just kind of disingenuous doublespeak, and we need to call it what it is. The US proposal could be implemented as an appropriate interim step, but the 300 billion would ultimately be left on the table, and we cannot do that. So my policy recommendation here would be to emphasize the importance of leaving open the possibility to restructure these loans in order to preserve the ability to seize the underlying entire 300 billion, satisfy the original bondholders, and still raise an additional 250 billion for Ukraine. Russia must be held accountable for the full extent of the damage that it's done, which already exceeds 300 billion. And anything else, including these creative financial engineering proposals, cannot let us take our eyes off the ball. Events and discussions like this, which I really want to thank you for, are important to dispel these myths that are circulating. And we need to start talking about the risks of what will happen if we don't seize the assets, rather than digging into reasons not to do that. So inaction is just as much of a policy choice, and it sets just as much of a precedent as action does. And that's something we need to remember going forward. The risks of actually not using the reserves are much higher, and we need to shift our perspective and our narratives about everything that we can do versus what we can't. And that is ultimately what will keep Europe safe.
Thank you very much. Thank you. Thank you, Yuliya. And to you, Ivan.
Thank you so much. Thank you, Svitlana, for a question. First of all, yes, there is a real danger of, also say a danger, a risk or an option that Russian Federation's government or Kremlin or Putin directly will order expropriation of assets of the European and US companies in the Russia. But I would avoid to call it confiscation. So it's a looting. It's a deprivation of property, because we need to understand that in terms of Russia, we cannot speak about the country of rule of law or something. And this can be a possible reaction, but again, as the practice shows, in cases which have already happened, in case of Carlsberg or Danone, these assets are transferred to the groups which are loyal. I'm answering correctly your question, yes? Yeah, okay. To groups who are loyal to Kremlin, especially from Northern Caucasus. And in this case, there are major risks generally for Ukraine and for general debate around the confiscation of assets and the future fate of the Russian assets. It's that Russia somehow suggests indirectly, so let's make it an exchange. So we are not looting or taking the assets of your businesses in Russia, and you are not taking, at least, or in best scenario for them, transferring back to Russia the assets of the Russian central bank. So this is a game which is very typical for Moscow, for Kremlin, and in this case, it's a test. It's a big test for a rule-based society in general, how to deal with it. But we need to understand that one major thing, that Russia, it's very unlikely that it will voluntarily agree to compensate Ukraine the damages caused by the aggression. There will be, it's unpopular thought in Ukraine, but there will be a political negotiations about how the war should stop. But I think, and those who know Russians, they will understand this might take that agreement to compensate for them will be even harder than to get out from certain Ukrainian territories. So it's a question of psychology and so on, and that's why it's really only this assets in the foreseen future are only reliable source of compensation to Ukraine and Ukrainians. In this case, I fully agree with my esteemed colleague Thomas Grant, with Yuliya and so on, that full confiscation of Russian assets is the main goal and possibly the best choice for all the parties, not only to avoid some legal risk, legal obstacles, but also to make this compensation realistic one. Because what we are talking today, these bones, what we are talking today about usage of profits, etc., this is okay for the ongoing support of Ukraine, which is very needed. Military financing of military, financing of budget, social spendings, etc. But currently, we are not seeing any strategy which can ensure the financing of the compensation to Ukrainians. We have register of damages. Next step, and as far as I know, there is a progress, should be a compensation commission, but the third step should be a compensation fund. And look, we don't have any option or any idea how to fill this compensation fund and how to start the process of paying the compensations. Even if or when the United States plan of loan for Ukraine will become possible, I really doubt that this money will be spent for compensation for Ukrainians. But all the other goals, as I said, ongoing financing of Ukraine is more than lawful and needed step. But still, only this 300 billions of the US dollars, whatever is the exact number, they are very needed to ensure the future paying of the compensation to Ukrainians. All the other choices are very doubtful. Ukraine, in this case, should also, from my point of view, take very seriously all the doubts and all the reasons which were currently expressed even in this room and during this event today. Because somehow Ukrainian government and Ukrainian officials, they are right that morally we have more than lawful right to get this money. But we need also to take into account economic, legal, political, especially, reasons from our allies. And what also this debate, which Thomas has mentioned about the countermeasures. These ideas were talked and were debated since the very beginning, or at least since the very first months of the full-scale Russian invasion to Ukraine. But at the end of the day, we have enough legal arguments, legal memos drafted by the very known and reputable lawyers. But we need also to have a political will to do it. We have seen how hard it was to take a decision on the usage of profits in the benefit of Ukraine. Now we see how it is or will be hard to take a decision on loan to Ukraine. Next step definitely should be a full confiscation. But there is a long road to do it, a long road to advocate this decision, and this event is very important as one of steps towards this decision. Thank you.
Thank you very much. I think it would be a good comment to conclude our discussion with experts, and unfortunately we're out of time, but if there are, and we are only 4 speakers left, but if you have some quick questions to our speakers, maybe we can take 1 or 2. Thank you. Sorry.
Thank you. So my question is related to the windfall profits. Basically, as far as I understand, that 90% will go through the European Peace Facility and 10% will go through the Ukraine facility, the Pillar 2 or Pillar 3. And so currently this percentage is 90 to 10, and it will be reviewed every year. And this year, 10% is because some countries, some member states were basically not agreeing to finance the war. And there are some safeguards to basically prevent changing of this percentage to even larger share going to broad recovery and reconstruction, basically going through Ukraine facility and not going to the direct needs of Ukraine for weapons. How can we ensure that member states, even more member states, will basically block this decision and demand larger share going through the Ukraine facility? Thank you.
Can you please introduce yourself?
I'm Katerina Hanina. I'm Ukrainian, and I'm a current trainee at the European Parliament.
Let's take 2 questions and we will finish.
Hello, thank you very much. It was really interesting. My name is Anna Caprile, and I work in the European Parliament Research Service. The European Parliament doesn't have a formal role in the CFSP and international EU policies, but pretends to have a big role in agenda shaping, what we call. So with that in view, we have financed some studies about that. And one of them looks at the legal options for Russian assets confiscation. And I'm glad to know that has been used by some of the experts. So this is a big introduction. For my question to Anna, I think would have been for Dr. Grant, but he's left. So exactly if the countermeasures were to be privileged or continue to be advocated as the best option, what are the mechanisms at the UN or international level that have to be triggered? Or can this be done without any UN decision, whatever, knowing that the Security Council is so far blocked? Thank you.
Thank you, Anna. On the question of countermeasures, it's an actually excellent question about how countermeasures are implemented in practice. So the idea of countermeasures is that it is a matter of self-help by states, available to all states who want to implement them. I would actually maybe disagree with Professor Grant a little bit in terms of how often or not or rarely countermeasures are used. There is an opinion by a prominent legal scholar, Martin Davidovich, on countermeasures that has been used in the past 10 years, that many of the sanctions that we are calling economic sanctions are, as a matter of international law, are countermeasures. Because as Professor Grant said, countermeasures is when you invoke some violation of international law against violating states in response to a greater violation of international law. So if we look closely at many of the economic sanctions imposed by the European Union against Russia since annexation of Crimea, many of them legally qualify as countermeasures. It just countermeasure is a term of public international law, mostly used in draft articles on state responsibility, and national legal systems or EU system uses the legislation on sanctions. But in fact, there is a very strong case to be made how there's a book about third-party countermeasures against Russia in the recent years. Many of these actions, when you do not invoke specific provision of law which gives you an excuse to apply this measure, for instance, if you have a free trade agreement on the World Trade Organization and you do not trigger the national security provision, all trade restrictions, including limitation on dual-use goods export to Russia, technically is a countermeasure. So this is one thing. Another thing that if we look closely at the drafting history of countermeasures of articles on state responsibility, which, as Professor Grant mentioned, took 50 years, it was discussed specifically that countermeasures will be especially needed and useful in a situation when you don't have a readily available judicial mechanism or when Security Council is blocked. This is the situation we have now, when there is no way, because international law is a system of horizontal enforcement, and it's a system of equal actors, sovereign states, and there is no formal law enforcement mechanism. The only quasi law enforcement mechanism is UN Security Council, which is blocked. And also Russia is abusing its veto rights. You know, Russia used its veto right to protect itself from international responsibility in Georgia, in Syria, and now it's doing this in Ukraine. So the idea of countermeasures is that it requires decision by the states to invoke it, not a third party or international organization decision. But there is something that can be done helpful, and many of these things have been done already. The UN United for Peace resolution, which was the first resolution on Ukraine, which recognizes that Russia committed acts of aggression, violated UN Charter, and that Russia must cease its invasion of Ukraine. Then we have already a provisional order of the ICJ, which is binding on Russia. And Russia has been violating it almost for 2 years already. And there is another UN resolution, General Assembly resolution of November 2022, where specific wording is that Russia must bear international legal responsibility, including paying reparations. So there's enough prerequisites already to invoke countermeasures, and no specific, it's just not the nature of countermeasures that you need a decision of any international organization to invoke it. And thank you for the report by Philippa Webb. I want to give shout out to this report, which is a tremendously helpful report in having this discussion because it is written by one of the most prominent scholars in international law. It's written in a very neutral way because like I have an agenda, I advocate for Ukraine, and many supporters of this idea advocate for for the confiscation. And I think it's helpful for policymakers to look at Philippa Webb report and to see what is neutral position, which is also supports countermeasures. Thank you.
Thank you very much to Katerina for the question. Indeed, the answer is in paragraph 11 of the Council decision, which was adopted on 14 May. This is where the key of distribution between the European Peace Facility and other European programs funded by the union budget is determined. So the 90% versus 10% indeed shall be reviewed every year. And for the first time before 1st of January 2025, as this paragraph provides. And this is done through a council implementing decision, which is adopted by qualified majority. And in the council, usually this is based on wide consultations. So we do hope that this review will happen by consensus by the end of this year, and then thereon once per year. I don't expect any problems with that. Now, should the needs of Ukraine change, and that is the reason and the only reason why we actually distributed the windfall revenues on the one hand for military purposes 90% and reconstruction 10%. We have consulted the Ukrainian government on this. Should those needs change, then this key would be changed in the light of those needs. And the initial idea was that 100% of the windfall revenues would go to the Ukraine facility and would be channeled through that. And because of the military needs which come now immediately before reconstruction, we changed that proposal. So that's the answer. Thank you. And thank you for the EPRS study, indeed, very useful.
Thank you very much. I hope our discussion was useful, and thank you for your participation.